One of the primary differences between textualism and the other philosophical schools of statutory interpretation concerns the use of legislative history in determining a statute's meaning. Most of the schools encourage the examination of legislative history. Countless judicial decisions, including Supreme Court decisions, have cited statutes' legislative histories in various ways. But textualism doesn't rely on legislative history. Former Supreme Court Justice Antonin Scalia, a new textualist even before he joined the Supreme Court, was the strongest modern critic of courts' use of legislative history. Justice Scalia contended that the use of legislative history to discern the intent of the legislature in enacting a statute violated the cardinal principle of our government that ours is, quote, a government of laws and not men, unquote. Justice Scalia's views have influenced virtually all courts at all levels. Many courts continue to use legislative history, but nowadays they do so more selectively. Broadly speaking, statutory history includes the entire circumstances of a statute's creation, evolution, and passage. Legislative history refers to the internal legislative prehistory of a statute, memorializing the proceedings and deliberations leading from the bill's first introduction to its passage. Legislative history may include various drafts of the legislation and statements by legislators, legislative committees, and staffers. It also may include correspondence and testimony from government officials, subject matter experts, citizens, and organizations. But the legislative history that courts more often consider is that generated by the members of the legislature themselves.